Good morning, everyone. My name is Doris Rodriguez, and we'll get started in just a few minutes while we give people a moment to get situated. So, if you need to get anything, please do so now. We'll get started in a couple of minutes. I also want to announce that this presentation is available with automatically closed captioning. Additionally, we are providing simultaneous interpretation in Spanish this morning, for which I will now provide instructions for our Spanish Zoom attendees to join. Hoy siempre brindamos servicios de interpretación simultánea para nuestros eventos, igual en persona o en Zoom. Por favor, de hacer clic en el globo al fondo de su pantalla donde dice interpretación. Luego haga clic en el idioma que desea escuchar, en este caso español. Si quiere escuchar solo al intérprete, puede también hacer clic en Mute Original Audio, que silenciará el audio original. Muchísimas gracias. Y de nuevo, bienvenido a Sinergia. Estamos agradecidos de tenerlo aquí. Before we begin, I want to let you know that we are broadcasting today's event live on Facebook page. So I want to give a warm welcome to those joining us there. Just give me a second to connect. Okay. So just a few housekeeping notes. Everyone who registered via Zoom will receive a copy of the presentation slide via follow-up email within the next few days. A survey will be shared in the chat and a QR code at the end of the presentation. We will have time at the end for Q&A. So we encourage questions at any time. However, please remember this is a public forum and we're being broadcasted on Facebook. As I mentioned earlier, my name is Doris Rodriguez, and I am the Autism Initiative Coordinator here at Sinergia's Metropolitan Parent Center. A few words about Sinergia's Autism Initiative. The Autism Initiative project is funded by a grant from the New York City Council under its Autism Initiative. This project supplements the work of Sinergia's Metropolitan Parent Center while bringing an increased awareness to New York City's residents, particularly to the community with large Spanish-speaking populations, about the growing number of children diagnosed with autism spectrum disorder. A strong outreach component targets families and children with suspected or non-diagnosis of autism spectrum disorder who are not receiving appropriate educational, health, and other related services. This initiative will link them to other services and supports that meets the individual's needs of children and their families. So I want to thank you for joining us. We are glad that you're here with us. Before we get into it, I would like to introduce our presenter today. I want to welcome Katherine Aquino-Meléndez, uh, senior attorney at Arkontaky Law Group. So glad you can join us today. We have so many
Thank you.
questions. So I'll hand it over to you, Katherine.
Great. Thank you so much, and good morning to all. Thank you for joining us this morning. I hope everyone's doing well. Like Doris said, my name is Katherine Aquino-Meléndez. I'm a senior attorney at the Arkontaky Law Group. Our home base is in Westchester County. However, we do service the entire state of New York, the city, Long Island, Westchester, Putnam, Dutchess, Orange County. With that said, our services also include, aside from guardianship and the alternatives for decision making, we do handle special education, litigation, and advocacy, special needs planning, trust administration, and applications for the Office of Persons with Developmental Disabilities, also known as OPWDD, and administrative appeals. I invite all of you to go onto our website, thearkontakylawgroup.com, if you have any further questions about our services or about us. Today, I will be talking about the guardianship and the alternatives that exist for the individuals with disabilities in New York State, whether it's a sibling, a friend, a neighbor, your own child. And hopefully you can all gain some information from this. A little bit about myself. I am a mother of two very sassy girls. I have a 5-year-old in kindergarten and a 2-year-old toddler. and they keep me very active. I live in Westchester County with my husband, and I'm also part of the board of directors for Joanna organization in Rockland County that provides services to individuals with disabilities. Um, Again, if you'd like to see more information about me, please visit our website. And excuse me, as Doris said, I will be answering questions at the end, so feel free to put your questions in the Q&A. I know that there were some pre-registration questions as well, and we will address those at the end. Thank you so much for your patience, and let's get started. So the first opportunity, or the first thing to discuss, right, is you have a child or an individual who's now 18 years old. In the state, they're an emancipated adult, which means that they can now make their own decisions. This trips up a lot of families, especially when their child has a developmental and or intellectual disability, because they may say, well, they probably can't make the decisions on their own, or they don't really know what's correct and what's not. And, how can I continue to help my son, my daughter, my sibling make decisions, right? And so there's different alternatives in addition to guardianship. And we'll go through each one, but I want you to understand that we're going to go from less restrictive to the most restrictive being guardianship. The least restrictive is advanced directives. This is typically, it includes a power of attorney, a healthcare proxy, a HIPAA release, a disposition of remains, and a living will. I'll touch on every document, but these documents are executed, right, or signed by the individual who's 18 years or older, but that also has the mental capacity to understand what they are signing. With that said, some individuals may not want to sign every document, and that's okay. Typically, for the younger adults, we have them execute a power of attorney, a healthcare proxy, and the HIPAA release. A disposition of remains and a living will can be a little bit more burdensome for the younger individuals. And so, typically they don't execute those. But again, it's their choice. And um, really, every adult should have them, right? I have them, my husband has them, and everyone who's participating today, if you're 18 years and older and you have the mental capacity, you should have these yourself. So what is a power of attorney? Power of attorney is a document that allows for you to designate an agent to make what we refer to as like business-like decisions, right? Purchasing product, items, banking, uh, transactions, real estate, stock purchases, applications, right? Simply applications maybe for Social Security. And the agent always has to act in the best interest of the individual because they are, being granted that authority, and it's the fiduciary obligation to always act in the best interest of the individual that is giving you that power. Typically, the individual will say, so and so, please go and do X for me, right? And so they're giving the agent the directive. This is a document that comes into existence once it's executed and dies with the individual who is the primary person on the document. It's easily revocable, right? You can shred it and it's no longer in existence. You can sign a new power of attorney. Some banks may have you sign power of attorneys, and you have to be very mindful about this because that can terminate maybe a more inclusive power of attorney. There's a healthcare proxy. Again, the individual designates a healthcare agent to make healthcare decisions for them when they're unable to make them for themselves, possibly because of incapacity. Your agent for your healthcare proxy should know what your wishes are, so it's always important to discuss and communicate with your agent what your wishes are regarding health and medical needs. With the HIPAA release, many of you have probably heard of a HIPAA release when you go to your doctor's office, maybe at your child's school. And a HIPAA release allows for the agent, whether it be, your healthcare agent, to access your medical record. It could be an individual appointed by the court who's acting as an attorney for you, right? If, for example, you're incapacitated because you have dementia, for example, the court may appoint uh, an attorney for you, and that individual can then access your medical history. The disposition of remains allows for you to dictate how you want your remains to be disposed of after you've passed. And a living will, expresses your wishes regarding artificial nutrition, respiration, and life-sustaining needs if you were in a situation of sorts. Now, we're moving through the spectrum into supported decision making. This is more like the middle ground, and this is something that has been around for some time. It's pretty much nationwide at this point. But excuse me, in New York State, the law, was being reviewed by the legislator, and it's been codified under Article 82 of the Mental Hygiene Law. And it allows for an individual with a disability to make choices of their own with the support of a team. And typically, you go somewhere, you kind of write up this contract with your team and what decisions they can assist you with and whatnot. Again, it's something that has been around, but there was no way of enforcing it previously in New York State. And it's a movement currently. For additional information, you can visit the National Resource Center for Supported Decision Making .org, and you'll see all the information. But this is beneficial for a lot of individuals, maybe not for everyone, and so that's why there's different alternatives. The advanced directives, which is the least restrictive measure. And it can be attempted, and if it doesn't work out, then maybe, you need a more restrictive option to assist the individual with disabilities. But as I mentioned, guardianship would be the most restrictive, right? And so there's two types of guardianships in the state of New York. There's an Article 81 guardianship, and there's a 17A guardianship. The Article 81 guardianship is part of the mental hygiene law, and it authorizes the court to appoint a guardian to manage the personal and or financial affairs of a person who cannot manage them themselves. For example, if an individual is developing dementia, or it's gotten to the point that now they have Alzheimer's, maybe they can't, manage their financial needs by themselves because their neighbor is taking advantage and asking them for money, and you believe that, maybe that individual is being taken advantage of, therefore you can seek for a guardianship under Article 81. This does take place in the Supreme Court of the state of New York, of the county, and it is a very lengthy proceeding. It's pretty much a whole trial. There's witnesses, there's testimony, there's evidence presented. And so highly recommend that if you're going to file for an 81 guardianship, you do so with the assistance of an attorney and not pro se, which means by yourself. This may not be the most appropriate guardianship for an individual with an intellectual and or developmental disability, but in some instances, maybe the court, per another order, requires that an 81 guardianship take place. And again, you can discuss the alternatives with an attorney who's well versed in the in the areas of special needs and guardianships. Now, a 17A guardianship, it requires a petition to the court, to the surrogate court within the county where either the petitioners reside or where the individual with disability resides in, who's often referred to as the respondent by the court, or the ward. Typically, the respondent, that's the title that is given to the individual with disabilities, but they can also be referenced as the ward. So you may hear me say those words interchangeably. But the petitioner, again, petitions the surrogate court to request to be appointed guardian of an adult child with, or an individual with an intellectual and or developmental disability once they've reached the age of 18. And I know that, like I said, we'll touch on the pre-registration questions, but when should you apply for guardianship, a 17A guardianship in the state of New York? And that typically, we used to say maybe around 16, 17, you could start the process because you want to avoid missing that gap for when that individual turns 18, right? And that's not to cause panic because if the individual is already 18 or even 20, you can still petition for guardianship. But you may start encountering issues, right? There may be instances where you're trying to apply that individual for Social Security now that they're 18 or 19 or 20. But the Social Security office may say, well, we can no longer speak with you because the individual's over the age of 18. If there's a medical emergency and, it's a physician maybe at the emergency room that is treating the individual with the disability who's over 18, they may not want to speak to the parents, for example, because that individual is now 18 and disclose the medical scenario to that individual. There's so many instances, and sometimes people say, well, I don't have any issues with my doctor's office. They've known me forever and they disclose everything to me. That's great. But you want to avoid ever being in a situation where you cannot communicate with the medical team, or if there's an emergency, or even assist that individual with applications, for example, with the Social Security office. Okay? And so these days, unfortunately, post-COVID, there was a significant backlog in the courts, and some courts, have yet to really catch up to staying up to date. Some courts in some counties move faster than others, but some counties just have way too many petitions and they just can't get through them fast enough. There's also been a more recent issue with one of the documents that we will look at. It's the OCFS form, and that goes up to Albany, the state capital. And there was a delay in getting that form and the report that comes with that form back into the courts, which was again causing a delay, right? And then you encounter issues with the petition itself, right? Getting all the documents done, getting the doctors to complete everything in a timely manner, submitting everything to the court, right? So there's delays that can happen throughout the process. But with regards to it once being in the court, you can have the issues of there being too many petitions in the court or things being delayed within the whole proceeding, right? With like OCFS form in the state capitol, or even the judge who's referred to as a surrogate. They may have too many cases on their docket or have other obligations, and they don't have the availability to hear the cases, you know, every week or as often as they wish. So there's a lot of things that can come up. And for that reason, you should definitely consider starting earlier than later for 17A guardianship. But again, remember, no need to panic if you haven't started it and your child is 21. You can still petition if it is appropriate for them to have a guardianship. And who would need a guardianship, right? You've heard me talk about intellectual and or developmental disability. And this is because of their disability, they're incapable of managing their own affairs, whether it just be, personal needs, right? So if they take medications, but really can't, control or know when to take a medication, that's a personal affair. If you're concerned about their safety because they can't travel independently, that's another concern, right? Staying in school. If you are the guardian and that individual maybe wants to sign themselves out of school at 18, they can, but if you're the guardian, you can advocate that they should remain in school because it's, their vocational program is going to better, help them in the future. If that individual has property, then you can also petition to be a guardian of their property. And there are certain properties that are excluded from the guardianship. Um, but again, it all depends on what it is and the application, which we'll look at some of the forms momentarily. So again, you can petition for person and or property of that individual. Where do you go to file 17A guardianship? It's the surrogate's court in the county where the child or the individual with disabilities resides, or the parent or guardian, right? The proposed guardian lives in. So, for example, if you live in the Bronx, you would petition in the Bronx court. But if you live in the Bronx and your child is at a residential facility in Orange County, you have all options of where to petition. You can visit the court's website, newyorkcourts.gov/courts/NYC/surrogates/index, to access more information as to what is required. There's DIY forms on the court's website where clerks can be contacted and answer questions for you. Some of them are more responsive than others, depends on the court, depends on, who's there. But typically they're very willing to help and provide guidance or answer your questions. They cannot provide you any legal advice, but they can, help you complete forms. Again, the court's website, forms, has directions. The forms are in PDF, Word. There's like fill in the blank ones. So again, it's very user friendly and one can do it themselves. To petition, right, you'll acquire all of these documents from the court, the website, or if you're working with an attorney, they will complete typically these forms for you. And one thing that I want to point out is that, a lot of individuals can petition for guardianship on their own. They don't need the assistance of an attorney. However, if you believe that there's going to be issues with the petition, right? Somebody's going to contest or argue that the guardianship should not be granted, or that the petitioner should not be appointed a guardian, you should seek the help of a legal attorney. You should also seek legal assistance if there are, issues with, for example, like criminal history or, some issues may come about with immigration. So you definitely want to seek the help of an attorney that, again, has the experience with guardianships. Typically, you'll have these documents to complete, and we'll look at every single one. So the first one, it's the physician and psychologist affidavit or affirmations, the petition, the consent, an affidavit, waivers, and the OCFS form, which I mentioned. So the physician and psychologist affidavit, this is to be completed by either a licensed medical doctor. Well, you're going to need two doctor affirmations. So either both can be completed by two medical doctors or a medical doctor and a licensed psychologist. And they have to complete every single question because you don't want to turn it over to the court and say, well, 4B was not checked off. Make sure to go through it and have every answer responded on that form because also it's going to be hard to get these doctors to go back and go through it again, and unless you go directly and you have that relationship with that individual and can say, here, complete, mark off real quick. But typically their staff will say, we'll handle it, we're touching base with the doctor, we'll get it to you, we'll get it to you, we'll get it to you. And it takes weeks and months to get back to you. Make sure that, right, some tips is that the doctor or the psychologist has seen the individual within the last 6 months or the time frame indicated by the court. Some courts require that it be 6 months, that the individual was seen by the doctor affirming in the form. Some of them allow for a year, right, that the patient has been seen within the last year, submitting the document. Again, just make sure that you know what the court's requirements are of the court you're petitioning in. Like I said, make sure that every answer has an answer on it because you don't want it to get kicked back from the court because you missed an answer. It's just going to delay the process again. If there's any reference to any testing, right? Ideally, you want to have a psychological testing referenced or some sort of evaluation. If that's the case, make sure to include that referenced evaluation with the affirmation to the court. The petition is a document that looks like this, and it is to be completed by the petitioners, right? You include the name of the parents, the respondent, and it's multiple pages. So don't think it's just this one page. It's a few pages of the petition. There's the the addresses of the individuals. If there's older siblings, right, who are 18 years and older, their information is required. Who lives in the house with the petitioner, their date of birth. I mean, there's various questions. And again, I encourage you, if you're interested, to maybe go onto the website and take a look, even if you're not thinking about petitioning this year, but maybe just take a look so you can familiarize yourself with the types of questions that are required. There is a filing fee, as you see on the upper right-hand corner, filing fee paid, right? This is completed by the court. There's a fee for filing. If you want additional certificates of guardianship, there's another fee for that. If you want letters, etc. Okay? And then the petition for appointment of guardian of person and property, or limited guardian of the property, right? So you can identify which one it is that you want to petition for. This is page 2 of the petition. Again, if the individual, the respondent, resides at a residential facility, 2B is to be completed. And this is also important when you get what's known as the citation, which is like the notice of the court appearance date. The director of the facility has to be served with that notice. And the court provides you directions as to who has to be served. I'll ask you to list again if the respondent has any property, right? If you're petitioning for property, who the standby guardians are going to be, and what the standby guardians, who are the standby guardians? It's, you can have one person be a backup or the standby. You can have two people be co-standbys. You can have one standby and maybe two alternative standbys. I mean, the designations can vary. The order can, vary as well. There's no right or wrong. If you want to appoint two guardians as the proposed guardians, maybe the two parents, they can be co-guardians, and then maybe an older sibling as a standby, an aunt or an uncle as an alternative standby, right? So they're like third in row. It really depends. There's no right or wrong. It's up to the petitioner's choice and, what the dynamics with the relationships are. The one thing is that just because you have a standby designated and the court approves that standby at the end, it does not mean that they will automatically become guardians if the guardian that is designated by the court is either deceased or incapacitated. That standby has 180 days to petition the court and let the court know, hey, court, I'm here. I'm ready to serve as guardian because Jimmy's guardians passed away and or incapacitated to act as his guardians. Right? Sometimes clients get very frazzled, like, well, I want to designate so and so and so and so and so and so, but like, I don't know what their life is going to be like in 10, 20 years. That's okay. You can always change a guardianship designation, right? I mean, you have to resubmit the request to the court, and maybe not every document has to be resubmitted to the court, right? Maybe one court does not require new doctor affirmations and just the petition. But you can change this. None of this is set in stone. And the same thing, again, remember, just because you designate someone doesn't mean that they're automatically going to be guardians. Their life may be very complicated when it's time for them to serve as guardians, and they won't want to take on that role. So, despite you having that conversation with them today, for example, in 10 years, there's no guarantee that they'll be willing to take on the role. So, you always want to be reassessing your planning and, the relationships in your child's life and your own life, and constantly reviewing your planning and whatnot. And that's, I mean, that's a whole other presentation which I think Sinergia might have in their archive, but that's a whole other thing of like planning and reviewing your planning and making sure that all your ducks are in a row, especially when you have a member in your family with a disability. The doctors, like I said, remember to get the affirmations done, and um, who, right? Maybe the primary doctor is different from who's completing the affirmations. And there's also a question as to like why you should be appointed guardian, how long you've known the respondent. The court wants to know what your educational background is. They also are very interested in knowing if you have any criminal charges, current, past, um, as well as addictions, right, to narcotics or alcohol. Sometimes, unfortunately, we've done things that we may have forgotten about because they were so long ago, but it's important to always disclose than for the court to come back and say, this came up on your record and it was not disclosed. Trust me, it's better to just put it out there than to get your petition kicked back because maybe you had ACS come to your house 20 years ago, right? Or you had um, some, maybe you committed, misdemeanor in your teen years or whatnot. It's important to always disclose. This is what the OCFS form looks like. It's the Office for Children and Family Services. Maybe if you work in a school or, around kids, you've had to complete this. But it basically does a background check on the individual that's, the adults that are petitioning, as well as in some courts, the standbys may be required to submit this form as well. And it's to, I always let people know it's a memory game because you have to go back 28 years and put your addresses for those 28 years. Some people have only resided in two places the last 28 years, and it's very easy for them to complete. Some people are constantly moving around, and it becomes a little bit more complicated. And you do the best you can. Sometimes the courts will say, if you can't remember the exact apartment number that you lived in 28 years ago, that's okay. As long as we have the address, that suffices. But again, it's important that you communicate with the court as to the questions you may have, because every court's different. Some are more particular than others. Some of them will be more lenient than others. So just make sure you're communicating if you cannot provide all the information. Again, this is the bottom part, and it'll just have it'll require like last names, maiden names, aliases, addresses, all of that fun stuff. Waivers. This is part of the whole petition packet, and it is for any parent or parents that are not petitioning to be guardians. Maybe there's a parent that's not very involved and they recognize that, and they're fine with the other parent petitioning alone. They choose not to be, a guardian. Um, Maybe they're just very ill and don't really foresee themselves being around much longer, and they just rather waive their guardianship role. An adult sibling, maybe you have another child that just turned 18, and you don't believe that you or they don't believe that that individual is capable of being a guardian. um, and so maybe you're designating them as a standby, but maybe they're just too young yet, right? Still to take on that role. And so they'll complete a waiver. Again, some courts have now been informing my office that they don't need the waiver if, it's a standby. But again, every court changes and every court differs. So make sure that you are confirming what is required in your county. And this is what a waiver looks like. And it pretty much says, right, you're renouncing to and consenting to the appointment of whoever's petitioning to be a guardian. And you're waiving being notified for service. A consent can again be for either the standby or the alternate standbys. And it is what it says, right? It's a consent that you are agreeing to the designations of appointment. And it also mentions, right, that again, if you can see maybe towards the bottom of the screen, that you will seek to have the court confirm your appointment within 180 days of you assuming the duties. So you have to go to the court as a standby and petition the court. So once you have all your documents prepared, you have your doctor's affirmations completed, signed, any evaluation that's referenced in that affirmation, what do? You file it with the court. Some courts are willing to accept a paper copy. Some courts will have you file it electronically. If you're working with an attorney, they will typically know what to do. And all the supporting documentation is filed with the court. The court will then issue, like I said, after everything's been reviewed, the OCFS form has been sent to Albany and returned back to the court, and everything looks good, the court will then issue the citation, right, which is the notice of a hearing date. You have to serve that citation on the respondent and any other interested party. So who is an interested party? Well, if your child lives as a residential facility, if your child lives at a residential facility, the director of that facility also has to be notified. Um, Maybe mental hygiene has to be notified, right? If they're at a residence or a group home. And then you file an affidavit of service with the court saying, I've completed my service. And be mindful that service has to be very specific. There's a certain timeline as to when you serve, if you're serving in person, if you're serving via mail, what days you can serve, and who can be served if that person cannot be served, right? There's very strict rules about service, but typically, there's information provided on the court's website on this. And this is what a citation may look like. It doesn't always look like this. Sometimes, the courts send you maybe just half a page completed with the information and who it has to be provided to. Additional items that may come up in your petition process. Again, it depends on the court. It's fingerprinting. Queens County, excuse me, requires fingerprinting. I believe Nassau County also more recently is requiring fingerprinting. Interviewing with mental hygiene legal services attorney, that pretty much has not happened since COVID, or a little bit post COVID, with the exception of if the individual is at a facility. The attorney for mental hygiene would go interview with the staff at the facility, ask questions about the petitioners, meet with the individual, ask them questions. They may call the petitioner and interview the petitioners as well. And in some instances, they may want to speak to the standbys as well. And you should be compliant, because it's only to help the process move along. Prior to COVID, mental hygiene attorney would be appointed and go to, an individual's home and tour the home and interview the petitioners and interview the individual. Then during COVID period, they would do like a virtual meeting. But a little bit after that time, they just started only handling the individuals that are in facilities. And the courts are then requiring for the respondent to appear in court with the petitioners. And they may do the questioning in court of both the petitioners and the respondent, the judge. So we have our citation, we have our hearing date. Who needs to be there at the appearance? Again, it depends on each court. Some counties will require the petitioners and the respondent to appear. Some will require the standbys to appear with the petitioner and the respondent. Some courts will do their hearings virtually, and everybody will be in a Teams meeting and everybody can hear and see everybody. Or it might just be a Teams meeting with just your case, right? And the judge. Some courts will require you to come in person, right? Westchester County last Wednesday, I was in surrogate's court with my clients and their children, and we had to appear in person. And the judge will ask questions of the petitioners and of the respondent. But again, it varies. Every court's different. Next Wednesday, I'm going to Nassau County and I have to appear with my client and their son. Again, because every court's different, as you've gained, it's the motto for this process is that some courts will let you know right then and there, I will grant the guardianship, and some of them will say, you'll hear from us shortly. I mean, typically they hint to the ruling. They may turn over the letters of guardianship right then and there if you're in court, or they may email them right away. Some of them will take a little longer to send you the letters of guardianship. But once you do get them, keep them in a safe place. Maybe take a, picture with your phone, keep it on your phone, scan it to yourself, keep it in a, priority email, laminate them if you need to, right? Just make sure to keep them in safe places. I tell, my clients, maybe share them with your child's doctor's office, right? So they can upload them onto their file. And that way, if you end up somewhere, maybe at a hospital where that doctor has privileges at, and they can access your son or your daughter's file, maybe they can also see that you are their guardian. Or you can pull up, from your phone. These days, there's so many apps and ways of saving things on your phones that you can probably have that with you. Never give over the original letters of guardianship, because then you're just going to have to pay for another original copy. Again, keep those originals with you in a safe place. Laminate them if you have to. With that, I will open, I guess, the floor for questions, Doris.
Yes. So as mentioned earlier, we will now open the floor for Q&A with our presenter. Please make sure to write all your questions in the Q&A or chat. Catherine, would you like me to start with the pre-registration questions or the?
Sure, let's start with those.
Awesome. So the first one is, my daughter is 17 years old. When should I begin guardianship?
Like I mentioned, the sooner the better, right? And it depends on which county you're located in, because some of them are moving faster than others.
Okay. The second one is there a partial guardianship? Would like for her to make decisions with, sorry, would like for her to make decisions with help of a trusted adult, myself, etc., family members.
So this is a pretty, it's a complex question in the sense that there's not necessarily a partial guardianship, but maybe guardianship may not be appropriate for that individual, right? And there's the alternatives, like I said, the advanced directives, the supported decision making. With that said, when you do file for guardianship, remember, despite you taking, and the reason it's the most restrictive, right? A guardianship is the most restrictive form of decision making, is because you're taking away all of that individual's rights, right? And you, with that said, you still have to take their wishes into consideration and what would be best for them. So I remember being in court one time, and the individual that I was representing, her family, she was a very capable young lady, but had some disabilities. And the judge in New York County asked her, do you wish for, these individuals to be your guardians? And she said, yes, because I cannot make all decisions by myself. And the judge, I distinctly remember, and this was even like during the pandemic period, so it was all like a virtual appearance, said to her and the guardians, I'm going to grant this guardianship, but you must always take the individual's wishes into consideration, right? Because at the end of the day, they're still a human, human being, and they may have some input. Whether it's the best option for them, what they want, maybe not always, right? But you should definitely take their input into consideration. And the courts will always emphasize that. Some courts, some judges emphasize it more than others, but definitely keep that in mind. And again, maybe, guardianship is not always the best option. I mean, perfect example, I had a client that whose daughter had an evaluation done very recently. She's a 20-some-year-old individual, and the recommendation by the evaluator was file for guardianship. When I met with this individual, she would never, the court would never approve a guardianship for her because of the way she expressed herself, the way she understood what I was explaining to her. Like, there was just I would not have felt comfortable filing for guardianship for this individual. And we executed advanced directives instead. She completely understood what she was signing. She even mentioned, right, that she has signed various HIPAA releases, because she was diagnosed at a much later time in life and her family had to be able to access the information. So maybe guardianship is not the best route. And I think that's why there's so much, heat against guardianship these days, because sometimes, unfortunately, certain processes are abused, right? And they're not appropriate for everyone. So be mindful about that.
Thank you, Catherine. If a sole custodial parent seeks guardianship of their minor child and there's been a history of domestic violence with the non custodial parent, will both parents need to consent to all aspects of the guardianship and its process?
So a custodial parent can file for guardianship, not for necessarily a minor, unless you're petitioning and the individual's like 17, right, or 16 with a disability. Um, if you don't want that other parent to petition with you, and you think there will be issues, right? It's going to be contested because that other parent's going to fight it, right? Because at the end of the day, if they're not petitioning, you either have to get them to sign the waiver. Remember, that's if a parent's not petitioning or an adult sibling's not going to petition. If they don't want to sign the waiver, or you don't, maybe you don't want to have that contact um, to meet with that other parent because of the domestic violence history, then maybe you just have to serve them the citation and they can appear at court. But again, if you believe that there is going to be issues, I would highly recommend you seek the assistance of an attorney who has experience in guardianship.
Thank you, Catherine. The next question, I think you might have answered it already. At what age should the documentation be started, and what paperwork is required?
Yes, so the paperwork, like I said, you should go onto the New York court's websites, specifically the county where you're going to petition at. If you're working with an attorney, I mean, my office, we complete everything. We do the service, we do the filing, we do everything. We follow up with the doctors, all of that. But if you're doing it yourself, you can go onto the court's website, maybe even go to the court, right? If you're near the court and you want to pop in and ask them for the documents, they might have the packets ready for you. And you should start as soon as possible. And again, some counties take longer than others. Um, so you want to, you don't want to have a lapse necessarily if guardianship is the appropriate route. But again, if your child or relative is over the age of 18, you can also file and you don't have to panic. So that's that.
Thank you. Alrighty, so we're moving on to some of our Q&A questions. Do we have to be residents or citizens to apply for guardianship?
So this is a very interesting question. Um, I feel like it always comes up, and there's nothing in the law that says anything about immigration status. However, some courts make an issue of it, and um, they may require you to petition with a U.S. citizen. Um, the OCFS Form 2, right? And I am mindful of the concerns that come with immigration issues. With that said, the OCFS form, right? It's something that sometimes a non-resident or a non-citizen wants to complete because it's going to bring up everything, right? It's going to do a whole background check if you've overstayed your stay, or you were here at one point and you shouldn't have been, right? It's gonna trigger things, and that form will eventually it may open a whole box of Pandora, but it's something that a lot of families have to think about and whether they want to proceed with the process.
Thank you. How important is guardianship when the youth turns 18 and still needs medical procedures? For example, the assessment for special education. Who provides the consent?
So this is a great question. And because I know that some agencies, once the individual is 18, they will say, parent, I can't speak to you or I can't help you with like special education advocacy because that individual is now 18. And the special education law indicates, right, that the parents can still like support their child with the special education. Guardianship is very important if it's appropriate. Um, but if there's a medical procedure and there's no issues being brought up and you don't have guardianship, that's fine, right? Um, I think the concern is always, if certain consents are required. M- Just again, using real life examples. I mentioned last week I was in court in Westchester County. One of my clients that day is a physician, but his son required a medical procedure and was going to have to be sedated. And that procedure is not happening for maybe next month, I believe it's happening. But he was like, do you think I'll have the letter of guardianship? Because I think I'm going to have pushback for the anesthesia and the sedation, being that now my son's an adult. And I'm like, yeah, I think I'll be fine. And this individual is a physician. His son is having a procedure where he works. They know his son is severely disabled, right? He's not even verbal, but that parent was concerned about that, right? So certain procedures, it may come up and it may not, and great if it doesn't. People go on with their lives for years without having a guardian appointed, and maybe sometimes we get calls that it's a sibling of an adult, like a mature adult. And maybe it was that parent that was taking care of everything, but that parent is now just too old or passed away. And that adult sibling is now trying to get guardianship of their mature sibling with a disability because there was never guardianship in place. And they just can't make any decisions for that individual, right? So things vary. Instances can vary, situations can vary, but if you can get it done, if it's appropriate, I would suggest you start soon and get that done.
Thank you, Catherine. Or for petitioners who have sole custody of a minor with disabilities and there's documented domestic violence case against a non-custodial. Oh, I think this is one of the same questions that were part of the pre-registration. So let me move on to the next one. Can the providers that the individuals with disabilities have to be a psychologist, or can the documents also be filled out by the attending social worker?
Mhm. So again, the doctor affirmation has to be completed either by two medical doctors or a medical doctor and a licensed psychologist. Um, so that's that answer.
Okay. Moving on to, I have a 14-year-old son, and in the past, I opened the case with ACS because his father left the apartment. I was sick, about to undergo surgery, and my son didn't have any services at home at that time. Is it necessary to mention this case in the process?
Um, I'm sorry. I'm looking at because the question, I have a 14-year-old son, that one, and in the past I opened a case. I think if I'm reading this correctly, Doris, and maybe you interpret it differently, the ACS case is against the father, but if the father is not being part of like if it's not part of the petition, there's no need to bring that up. It's if the petitioner has anything, any cases against them, any prior charges, anything of that sort. Is that how you interpret it too? That it's the father that had the ACS case and is not petitioning? And I see something about right about that one, like the Queens County Court. Um, but yes, you're right. A disability does, you know, does not have a look. Um, so that's a response to that. They're saying how, the individual came to court all dressed up and the judge didn't really find it appropriate to appoint guardianship, I guess. Sorry about that.
Can you hear me, Catherine?
I can hear you now, Doris.
Awesome. Alrighty. Can I move on to the next question?
Yes.
My daughter just turned 18 years old, and my care coordinator seems to be not concerned that we have not been active in getting things going for guardianship. Are there any other places to get psychological evaluations done besides YAI?
Yes, they are.
I know there's somebody made a comment um, on the Q&A, but I do believe that it was a lengthy question and it was answered. However, you can reply via email, and we will be happy to answer that question more directly. I also noticed that some had their hands up. If you can just direct your questions to the Q&A, we'll be happy to answer them. And regarding the evaluations, I know that they asked if there's any places that you recommend right now. Um, we can also follow up with you via email unless you want to answer that live, Catherine.
I mean, maybe if you have a decent school one, if you know of any other psychologists, sometimes we refer families out to agencies, um, various agencies, right? If they need an updated psychological. I mean, there's so many places to get these assessments, and I'm sure Sinergia has probably a list of locations as well.
Yes, I will follow up with Ms. Um, initials LB via follow-up email
Yeah,
with that
if
information.
I could just, I'm sorry, Doris, but
No,
I
go ahead.
believe hers was like the whole Queens thing and the appearance. I
Correct.
didn't realize you were asking if it can be appealed, LB, but I would speak to an attorney about that. And that's a very specific question, with a lot of very specifics, so I can't provide you a response for that. I would advise you to reach out to an attorney.
Thank you, Catherine. All right. I think that's it for our questions. Awesome.
Okay.
So thank you so much for joining us today. We hope that you enjoyed today's presentation on guardianship and alternatives. Special thanks to our presenter for leading this webinar on such a great important topic. Thank you, Catherine.
Thank you so
Um,
much.
So we do encourage you guys to stay for just a few minutes just to complete our survey, which you guys can find on the chat. So again, if you have any questions that you would like to share with us, with the presenter directly, please let me know and we will get to you via contact. For those joining us via Facebook, to secure a copy of the materials from today's webinar, please contact our intake line. This presentation will also be posted on our YouTube. So thank you. And thank you to our interpreter. And thank you, Catherine. And
Yes, of course. I'm
that
happy
concludes.
to stay a few more minutes if you want, Doris, in case some people have additional questions.
Yes. Somebody did ask about, I guess, your information, Catherine. I don't know if you want to put it on the chat, or I can also share them with, like I mentioned, I will send over an email with the link from our Facebook Live. Links from today's presentation, the PowerPoint. And again, like I said, if you have any questions, feel free to contact our agency and we will be happy to answer them.
Yep. Can I type my answer. I'll put my information. Hopefully it goes through. Can everyone see it? I hope I answered it.
I can't see it.
Um, let's see. Maybe if I do this. No, maybe she's the only one that can see my response. Well,
If you directed it to the person on the Q&A, then yes, they should be able to receive the message
okay.
directly.
Um, just for recap, it's the Arkontaky Law Group, Arkontaky, Law, LAWGROUP. Our main office number is 914-460-7880. And if you call in, one of our intake coordinators can assist you in scheduling something.
I've also included the information on the chat. Awesome. So again, thank you everybody for being present. Please complete our survey, and we look forward to seeing you in our next presentation. Thank you, Catherine.
Thank
You
you.
have a good
So great,
one.
everyone.
Bye bye.